In this fourth lecture in my Big Picture series, I want to turn to the Territorial Constitution. I want to look at devolution and at what light it can cast on the nature of the British Constitution. In particular, I want to ask the question, what does devolution tell us about the flexibility or otherwise of the British Constitution? And so in asking that question, I'm referring back to the overall aim of these lectures, which is to explore the extent to which the UK Constitution is essentially malleable, essentially a blank canvas on which politicians and lawmakers can paint it will, as against the possibility that it has a degree of inherent fixed content that is resistant to interference by legislative or other means. Now, in some senses, devolution is the ultimate illustration of the UK Constitution's flexibility or malleability. And we can think about this in a number of respects. First, the scale of the changes introduced through devolution has been immense. Devolution amounts to nothing less than a major reinvention of the constitutional architecture of the UK. And one of the striking things, moving on to the second point, is the way in which that was accomplished, that these really substantial changes, which were broad in scope and deep in terms of their constitutional implications, were introduced by nothing more than regular Acts of Parliament. And of course, there's nothing else that they could have been introduced through in the absence of a written constitution. So whereas in many countries, the introduction of constitutional changes as far-reaching and as significant as devolution would have required a probably very hard to comply with and certainly elaborate constitutional amendment procedure to be negotiated. In the UK, it could be and it was accomplished by nothing more than the enactment of ordinary legislation. That leads on to and explains a third point, which is that devolution, as it has been said, is a process rather than an event. What's meant by this is that devolution is something that is in effect a work in progress, something which is built upon, changed and amended as part of an iterative process, as opposed to a set of one-off constitutional changes that were put in place and then simply left as they were. We can see this through the fairly regular changes that have occurred, particularly to the Scottish devolution settlement, where over a period of time the powers conferred on the Scottish Parliament and government have been extended. We can see it too in relation to Wales, where the very model of devolution has evolved through a number of iterations since devolution was first introduced over 20 years ago. And this is of a piece with the idea that in the UK, reform, or certainly flux, is a natural constitutional state. Because the constitution is easy to change, the constitution is often changed. Fourth, and finally, devolution as an illustration of the constitution's malleability is illustrated by one of its cardinal features, in the sense that devolution presupposes and relies on the very elasticity of the Constitution. In the UK, we have no fixed division of authority in the way that, for example, a federal constitution would have, where power is divided between the state and the federal levels. Rather, devolution buys into and harnesses the fact that in this sense the canvas is indeed blank, and that the UK Parliament, by enacting and then amending the devolution statutes, is able to allocate competences to the devolved institutions as it wishes. That's why and that's how the process of reform, the iterative process of devolution that I just described, has been possible as the Westminster Parliament has adjusted the allocation of powers to devolved institutions over time as the devolution systems have bedded in and as public opinion has developed in the devolved nations. So in those senses, as I say, devolution is a very graphic illustration of the malleability of the UK constitution. At the same time, there are certain fixed points, and perhaps the most significant of those fixed points is the sovereignty of the Westminster Parliament. And we can see this clearly in the Scotland Act 1998, and we can see it equally clearly in the other devolution statutes. And I'll refer here just to the Scotland Act. So section 28, subsection 1, tells us that, subject to the restrictions laid down later on in section 29, the Scottish Parliament can make laws to be known as Acts of the Scottish Parliament. So section 28.1 is the foundation of the Scottish Parliament's authority to make law. Alongside the limitations set down in section 29, section 28 itself lays down an important limitation of sorts. In section 28, subsection 7, we're told that this section, which authorises the Scottish Parliament to make law, does not affect the power of the Parliament of the UK to make laws for Scotland. So what this is telling us is that the fact that power has been conferred on the Scottish Parliament does not diminish the powers of the UK Parliament. In this sense, the UK Parliament is lending its authority to the Scottish Parliament by giving it the power to make certain laws, but it isn't relinquishing any of that authority. It isn't even lending the authority on an exclusive basis. It's lending it on a non-exclusive basis because it isn't giving up any of its own powers. Now, alongside the principle of parliamentary sovereignty, as it applies to the UK Parliament, there's arguably a second fixed point within the devolution architecture, and that is in the form of the Sewel Convention. The Sewel Convention says that the UK Parliament will not normally legislate on devolved matters without the consent of the Scottish Parliament or of the other devolved legislatures. By devolved matters in this context, we mean both matters that already lie within devolved competence and matters that affect the scope of devolved competence. And as is often the case with the UK Constitution, it's impossible to have a full understanding of the picture until we overlay the legal position with the conventional position. If we take section 28 of the Scotland Act on its own, the implication seems to be that the position of the UK Parliament is unchanged. Its powers are undiminished. Its capacity to enact law for Scotland or for the other devolved nations is unaltered. And yet, when we overlay the Sewel Convention, the picture changes significantly, because now we're told that notwithstanding the legal possibility of UK legislation on devolved matters, the political practice is that such laws will not be made unless the devolved Parliament in question consents to that. So here we have a clear example of the way in which the legal and the political constitutions operate together and interact in the UK. In legal terms, the principle of parliamentary sovereignty appears to be a threat to the principle of devolved autonomy, the idea that the devolved nations, having been established with their own parliaments and executives, should be left within the scope of their authority to govern themselves. But sitting alongside that legal position, we have the political position as represented by the Sewel Convention, which institutionalises the principle of devolved autonomy. And as we put those two things together, we then gain a full understanding of the position, which is that while Westminster remains legally competent to legislate, the political understanding is that it generally will not do so unless invited to by one of the devolved institutions. There is a further complication, and that is found in section 28, subsection 8 of the Scotland Act, which was inserted following the independence referendum in Scotland. Here, we're told that it's recognised that the Parliament of the UK will not normally legislate with regard to devolved matters without the consent of the Scottish Parliament. So what section 28, subsection 8 is doing is acknowledging in statute the existence of the Sewel Convention. This seems to blur the distinction between the legal position and the political or conventional position, because now we appear to have, in law, an acknowledgement of the convention. Well, this gives rise to a number of issues and questions that I want to explore in the remainder of this lecture. If we think back to our idea about the extent to which the Constitution is flexible or otherwise, parliamentary sovereignty would appear to be the ultimate fixture. In fact, it might be said that parliamentary sovereignty, at least on one view of the Constitution, is the one fixed point within it, and that everything else really follows from that. Certainly, the idea that the Constitution is a blank canvas on which politicians and lawmakers can paint at will, that idea flows directly from the idea of parliamentary sovereignty. It is the very sovereignty of Parliament that enables the Constitution to be treated as that blank canvas, in the sense that nothing is sacrosanct. Nothing that has been painted onto it cannot be erased, because, as Dicey said, as we saw in the first lecture, Parliament can make or unmake any law. The difficulty, of course, is that if that is the one fixture, and if nothing else can be fixed, because everything else is vulnerable to an exercise of sovereignty, then this threatens other, potentially competing constitutional principles, such as the principle of devolved autonomy, to which the Sewel Convention gives expression. And so in respect of that competing principle, the principle of devolved autonomy, a number of questions arise. Is convention sufficient to provide protection for it in the face of sovereignty? Is convention more generally sufficient to enable competing principles to emerge and to become embedded within the Constitution? And how, if at all, does the statutory recognition of the Sewel Convention that we now find in section 28(8) of the Scotland Act, how does that affect our analysis of these points? Well, let me deal with that latter question to begin with by turning to the Supreme Court's judgment in the Miller 1 case. As I said earlier, the Sewel Convention is now understood to apply not just to legislation on matters that have been devolved, but also to legislation on what is devolved. In other words, legislation that determines the scope of devolved competence. Now, the Miller 1 case was the case in which a legal challenge was brought to the UK government's plan to trigger the UK's departure from the European Union under Article 50 of the Treaty on European Union. For the most part, the case was concerned with questions about whether the triggering of Article 50 could be achieved using the royal prerogative powers of the government, or whether legislation would be needed. The court eventually decided that legislation would be needed. That raised a further question regarding the Sewel Convention. It was clear that legislation enacted to trigger Article 50 of the Treaty on European Union by bringing about Brexit, or at least by initiating the Brexit process, would ultimately produce changes to the scope of devolved competence. The reason for that is that while the UK was a member of the European Union, EU law was itself a limitation on the powers of the devolved institutions. Departure from the EU, effected by this legislation, would change that. So it was argued by the devolved institutions that the Sewel Convention would apply, that because the Article 50 legislation would affect the scope of their devolved powers, they said that it shouldn't be enacted unless they agreed to it. And so the argument was that the Sewel Convention was relevant here and that devolved consent was required. Well, that argument didn't find favour with the Supreme Court, not so much because the court disagreed with the substance of the argument, but rather because the court refused in the first place to engage with the argument. Here's what the court said. It looked at section 28.8 of the Scotland Act and said that by inserting that provision into the Act, the UK Parliament had not been trying to convert the Sewel Convention into a legal rule that could be interpreted, let alone enforced by the courts. Rather, said the Supreme Court, Parliament was simply recognising the convention as a convention and declaring it, in effect, to be a permanent feature of the relevant devolution settlement. This, said the court, followed from the content of section 28.8 and from the nature of the language used. The court said that it would have expected the UK Parliament to have used different words if it was trying to convert the convention into a legal rule that would be justiciable and enforceable by the courts. So the answer to our question whether section 28.8 makes any difference to this, whether it, for example, adds some additional force to the Sewel Convention, would appear to be no, because to begin with, the Supreme Court rejects the idea that section 28.8 alters the nature of the Sewel Convention. It remains a convention. It hasn't, says the court, been converted into a law. Now, following the Miller 1 judgment, UK Brexit legislation was enacted, and some of it was enacted without the consent of all of the devolved institutions. This may be thought of then as a demonstration of the continued potency of parliamentary sovereignty, as an ultimate illustration, if you like, of the blank canvas view of the Constitution, that the principle of devolved autonomy is tolerated only to the extent that the UK Parliament is willing to tolerate it. And that's certainly one way of understanding what happened here. But the picture is more complex than that, and there are difficulties with this view as well. One way of trying to understand that is to think of the way in which parliamentary sovereignty emerges from this episode as something of a double-edged sword. On one view, as I've just said, we can see it as the ultimate guarantee of the Constitution's malleability. Because Parliament is sovereign, nothing is set in stone, nothing can't be changed, nothing can be set up in opposition to parliamentary sovereignty, nothing can be set up in opposition to Parliament's capacity to shape and to reshape the Constitution as it wishes at any particular point in time. And that means that a principle such as devolved autonomy as a political or conventional construct is no match for the legal might of the sovereign UK Parliament. But even if we put to one side the immense political difficulties that may follow from the muscular insistence on sovereignty that we saw in the wake of the Miller 1 judgments. There's a further set of difficulties with all of this. And the difficulty is that this insistence on sovereignty as a trump, as something that takes priority over everything else, may, on the one hand, ensure the malleability of the Constitution, or at least its malleability at the hands of the UK Parliament, but it may at the same time pose a risk to other constitutional values. It may even pose a risk to the territorial constitutional stability of the UK by preventing the emergence of a constitutional settlement that actually meets the expectations and meets with the acceptance of the entirety of the UK, including the devolved nations and institutions. We can see an example of that in a paper published by the Welsh Government called Reforming Our Union, Shared Governance in the UK. In that paper, the Welsh Government said that whatever its historical origins might be, the UK is now best seen as a voluntary association of nations taking the form of a multinational state. Its members share and redistribute resources and risks among themselves to advance their common interests. Wales, said the government, is committed to this association, which must be based on the recognition of popular sovereignty in each part of the UK. Parliamentary sovereignty, as traditionally understood, no longer provides a sound foundation for this evolving constitution. So what is the Welsh Government arguing here? Essentially, it's arguing that the notion of parliamentary sovereignty, the idea that all legal authority resides in or originates and flows from the Westminster Parliament in London, is not fit for purpose in, as it sees it, a multinational state consisting of a voluntary association of nations. The difficulty with the view of parliamentary sovereignty that I sketched earlier is that it's, on the one hand, while it safeguards a kind of flexibility, it also injects a kind of rigidity into the Constitution. If parliamentary sovereignty really is as absolute and as fixed as orthodox theory suggests it is, it's hard to see how, should the political will be there, the kind of understanding of sovereignty and the kind of governance arrangements that the Welsh Government favours could be introduced. And introducing those kinds of arrangements, a more flexible structure, a structure that recognises the equivalence of the nations within the UK, as opposed to the kind of top-down approach that devolution implies, may in practice be a necessary step to take if the territorial integrity of the UK is to be preserved. Flexible structures are generally stronger than brittle structures, and the risk is that slavish adherence to an unreconstructed understanding of parliamentary sovereignty may render the UK state a brittle structure that is unable to adapt to the kind of changes in governance that might be needed to allow the UK to continue along the lines, for example, that the Welsh Government would favour. That's not to say that the Welsh Government's view is necessarily the best understanding of all of these questions. It is an important and an interesting view, but there are obviously a number of different views out there. But my point is a more general one. My point is that in order to accommodate changing understandings and expectations, the way in which the UK Constitution operates may need to adapt. And it's not entirely clear that that adaptation is possible if we stick to a very traditional understanding of parliamentary sovereignty. And so finally on this point, we arrive at a sort of paradox. On the one hand, parliamentary sovereignty is the ultimate guarantor of the Constitution's flexibility. It's the ultimate guarantor of flexibility in the sense that it ensures that nothing is beyond change and that everything is subject to relatively ready change, in that it can be accomplished simply by a majority in the UK Parliament. But at the same time, that view that Parliament is sovereign and that it therefore ensures the flexibility of the Constitution is in itself a rigid view. It presents a rigid view of sovereignty, and in that overarching sense, it presents a rigid view of the Constitution, in which the sovereignty of the Westminster Parliament is a constitutional fixture, and may, certainly viewed from the perspective such as that offered by the Welsh Government, it may be therefore regarded as a roadblock to constitutional change and development. And it's in that sense that sovereignty may be regarded as a double-edged sword, something that at once is both a tool that can be used to achieve great flexibility, but whose own rigidity may prevent changes that could be needed to allow the Constitution to adapt to new circumstances.